now my pleasure to introduce our outstanding expert panel. These panelists have come from far and near to be with us today, and we certainly welcome them, and we certainly want to tell each and every one of you beforehand that we thank you so much for taking the time out from your busy schedule to participate with us in this hearing. I'd like to first of all introduce you now. From my left, my far left, is Ms. Eileen Harrington. Ms. Harrington is the acting director of the Bureau of Consumer Protection for the Federal Trade Commission. Next to Ms. Harrington is Mr. David M. Sohn, who's the Senior Policy Counsel for the Center for Democracy and Technology. Next to Mr. Sohn is Mr. Robert W. Holliman II. Mr. Holliman is the President and CEO of Business Software Alliance. Seated next to him is Mr. Martin C. Lafferty. He's the Chief Executive Officer of the Distributed Computer Industry Association. I think I got that right. Next to Mr. Lafferty is Mr. Stuart K. Pratt, President and CEO of the Consumer Data Industry Association. And then followed next to him is Mr. Martin Rodenberg, I think I pronounced that right, who is the Executive Director of the Electronic Privacy Information Center. And the gentleman next to Mr. Rodenberg is Mr. Robert Bobak. He's the CEO of the Tyversa Incorporated. And lastly but not least, the gentleman that's seated next to Mr. Bobak is one Mr. Thomas D. Sittner. He's a senior fellow and director of the Center for the Study of Digital Property of the Progress and Freedom Foundation. Again, I want to thank each and every one of the witnesses for appearing today. It is my pleasure to extend to you 5 minutes for the purposes of opening statements. And we will begin with Mrs. Harrington. Mrs. Harrington, would you pull the mic close to you and hit the button to turn it on? Thank you so much.
Thank you very much. Chairman Rush, Ranking Member Radanovich, and members of the subcommittee, I'm Eileen Harrington, the Acting Director of the FTC's Bureau of Consumer Protection. I appreciate the opportunity to appear to present the Commission's testimony on data security and peer-to-peer file sharing. The Commission's views are set forth in its written testimony. My oral presentation and answers to your questions represent my views. Let me start with data security. Companies must protect consumers' sensitive data. If they don't, that data could fall into the wrong hands, resulting in fraud and consumers losing confidence in the marketplace. The Commission has undertaken substantial efforts described fully in its written testimony to promote data security. Let me highlight 3 particular efforts for you: our law enforcement activities, our pending rulemaking on health information security, and our study of emerging technologies. Today, the Commission announced its 26th law enforcement action against a business that we allege failed to have reasonable procedures to protect consumers' personal information. Case number 26 is against mortgage broker James Nutter and Company for allegedly failing to implement basic computer security measures. In settling these charges, the company has agreed to maintain reasonable security measures in the future and to periodic outside audits of its security practices. The Commission's data security cases are well publicized and send a strong message to the business community. You must have reasonable data security measures in place. Second, a few weeks ago, the Commission issued a proposed rule to require that consumers be notified when the security of their health information is breached. The proposed rule arises from a mandate in the Recovery Act to address new types of web-based entities that collect or handle consumers' sensitive health information. Covered entities include those that offer personal health records, which consumers can use as an electronic, individually controlled repository for their medical information. Personal health records have the potential to provide numerous benefits for consumers, but only if they have confidence that the security of the health information they put in it will be maintained. Third, the Commission continues to examine new technologies to identify emerging privacy and data security issues. In February, for example, the Commission staff released a report recommending principles for industry self-regulation of privacy and data security in connection with behavioral advertising. We are also considering a petition submitted by Epic raising data security concerns about cloud computing services provided by Google. Finally, a few words about the proposed data security bill, H.R. 2221. The Commission strongly supports the goals of the legislation, which are to require companies to implement reasonable security procedures and provide security breach notification to consumers. We also strongly support the provisions that would give the Commission the authority to obtain civil penalties for violations. We have provided technical comments to committee staff, particularly with regard to the scope of the proposed legislation and the data broker provisions, and very much appreciate the opportunity to provide input. Turning to P2P file sharing, let's be clear about one thing. The FTC's interest is the safety and privacy of consumers' personal documents and information, not copyright piracy. Although P2P technologies may offer benefits to computing, they have also been associated with significant data security risks. The press has reported disturbing instances of sensitive documents being shared via P2P networks. Sensitive documents likely have been shared under three scenarios. First, some consumers may have shared documents because they failed to read or understand information about how to keep files from being shared or did not understand the consequences of altering default settings. Second, some consumers may have unknowingly downloaded malware that caused their files to be made available on P2P networks. Third, some businesses and other organizations that hold sensitive personal information, such as tax or medical records, have not implemented procedures to block installation of P2P file sharing software on their company or organization-owned computers and networks. Some of the most highly publicized instances of personal information being shared over P2P networks occurred because businesses failed to prevent the installation of P2P software on their systems, or because their employees placed sensitive corporate documents onto home computers that had downloaded P2P software. The FTC has worked with the P2P industry as it has set standards for disclosure and default settings that protect consumers' files and information. We have received reports about the performance of 7 P2P companies and are currently reviewing them to see whether these companies comply with the industry standards. We will make the results of our review public this summer. We also educate consumers about the risks associated with these programs. In addition to a 2008 consumer alert, the FTC's Internet Education website, onguardonline.gov, highlights information about the risks of P2P file sharing software. Finally, we support legislation that requires distributors of P2P file sharing programs to provide timely, clear, and conspicuous notice and obtain consent from consumers regarding the essential aspects of those programs. H.R. 1319 may provide very useful protections for consumers. The agency has worked with committee staff on previous versions of the bill, and we look forward to working with committee staff again regarding this proposed legislation. And we thank you very much for giving the FTC the opportunity to present its views today.
The chair now recognizes Mr. Sohn for 5 minutes.
Chairman Rush, Ranking Member Radonovich, members of the subcommittee, thank you for the opportunity to participate in today's hearing. The Center for Democracy and Technology is very pleased to see this subcommittee focusing on data privacy and security issues. Based on my conversations with subcommittee staff, I'm going to focus my comments this afternoon on the Data Accountability and Trust Act with just a few words at the end about the Informed P2P User Act. But before I do that, I'd like to make a general point. Both of the bills that are the focus of today's hearing reflect the fact that technology has greatly expanded the ability to collect, store, use, and share personal data. The modern information economy that this makes possible has many benefits, but it also has greatly changed the privacy landscape, and it has expanded the risk of inappropriate disclosure of personal data. Unfortunately, the law has simply not kept pace with these changes. In particular, the United States has no general privacy law establishing any kind of fair baseline of principles or expectations to govern consumer privacy. And in the absence of that kind of overall legal framework, when new privacy issues arise, Congress is essentially left to legislate on a one-off basis without any clear guiding principles and without necessarily much consistency. The result, what we have today, is a confusing patchwork of laws in this area. So based on that, CDT would certainly urge the subcommittee to put a high priority on the enactment of baseline federal privacy legislation, and we're very happy to hear Chairman Rush saying today that he plans a joint hearing and does plan to work on comprehensive privacy legislation. Now I'd like to turn to the Data Accountability and Trust Act. CDT supports the idea of a nationwide data breach notification standard so long as that standard is at least as effective as the laws already in place at the state level. The key point to understand here is that data breach notification is already the law of the land because it is required by all but a few of the states. So from a consumer perspective, replacing state notification laws with a weak federal standard could actually be a step backwards. And even replacing them with a good federal standard still doesn't offer a lot of tangible progress. The principal consumer gains from H.R. 2221, therefore, come from Section 2 of the bill, namely the provisions requiring data security procedures and especially the provisions requiring information brokers to let consumers review what's in their data broker files. Based largely on these provisions, CDT does support the framework set forth in the bill. My written testimony offers some suggestions for improvements to the bill. For example, the breach notification provisions could be improved by requiring a company that suffers a breach but determines that there isn't enough risk to notify consumers to nonetheless provide a brief explanation to a regulator, basically just to keep everybody honest. For the provisions on security standards and consumer access to information broker files, CDT recommends taking a close look at the scope of those requirements. In particular, the bill uses a definition of personal data that's really quite limited, which may make sense for breach notification provisions, but might make less sense for the provisions in Section 2. Preemption deserves a mention as well. It's important to note that preempting state laws in this area is a very significant step. The only reason we're here talking about breach notification today is that notification laws were pioneered by the states, and especially California. States were able to do that because the Gramm-Leach-Bliley Act preempted inconsistent state laws, but otherwise left states free to experiment. Fortunately, the authors of H.R. 2221 have been careful with preemption. CDT does believe that preemption makes sense for the specific issue of breach notification, and the bill does provide for that. I just say that as the bill moves forward, Congress needs to keep in mind that the price of preemption must be strong federal action, and that overbroad preemption has to be avoided. Overall, CDT does appreciate the careful work of Chairman Rush and the other sponsors of this bill, and we stand ready to cooperate with them on possible improvements as the bill moves forward. Finally, just a couple words on the Informed P2P User Act. CDT absolutely supports the principle that file sharing software should clearly communicate to users how their files may be made available to third parties. Inadvertent sharing of personal files is a very serious privacy matter. As set forth in my written testimony, however, legislating in this area does pose some difficulties. CDT has reservations about the potential unintended breadth of the bill, and also has some reservations about Congress starting down the path of imposing specific design mandates for software developers. That said, we share the broad goal, and my written testimony offers some ideas for modifications to consider if the subcommittee chooses to proceed with the bill. Thanks again for the opportunity to testify.
The chair thanks the gentleman. The chair recognizes now for 5 minutes of opening statements Mr. Holloman.
Mr. Chairman, Ranking Member Radonovich, other members of the subcommittee, I want to thank you for the opportunity to testify today. The Business Software Alliance represents the leading developers of software and hardware. Of the software that is sold around the world, roughly 90% of that is from companies who are U.S.-based companies. And our members believe strongly that the type of inquiry that this committee is engaged in today is important, not only to ensure that our customers are using software properly, but also to ensure that the promise of electronic commerce, and equally important, the promise for the type of sensitive data that the government will hold and does hold, that we can have greater confidence, because that will add enormous efficiencies to our system. As we look at the issue of breaches, the data is astounding in terms of the problem that we've seen. I won't repeat all of the information that has been so widely covered in the press and by the subcommittee, except that I will note that the trend is that data breaches are growing. In 2008, it was estimated that there was a 47% increase in data breaches over the prior year. And the average cost of each breach is growing. And for the 9th year in a row, the identity theft has topped the list of FTC consumer complaints, about 26% of all their complaints. And according to the Privacy Rights Clearinghouse, a staggering 270 million records containing sensitive personal information have been affected since 2005. And certainly, we've heard on this panel today, you've heard in your opening statements about Heartland Payment Systems, the single largest fraud-related data loss ever in the U.S., estimates of over 100 million individual credit and debit card accounts were compromised, and the consequences of that have been enormous. And finally, to the point that I made about the importance of government data, nearly 20% of all data breaches involve government, federal, state, and local governments. And as we move to the promise of governments holding even more sensitive data regarding to our health records, as people live longer, as our population grows, as we build the kind of openness and confidence in government, we have to ensure that that important nexus is also protected. With that, Mr. Chairman, I'd like to comment on your pending bill. We believe that this bill, Mr. Rush, makes significant contributions to restoring and building a goal of consumer citizen trust. We support its effort to establish a uniform national standard and provide the preemption of state laws. We also believe that it's important to recognize that it would prevent excessive notification. We do need notification, but not all breaches are equal. And part of what we need both in business, but part of what consumers need is to ensure that when the notification occurs, it is the result of something that is meaningful. Third, we support exempting from notification data that has been rendered unusable, unreadable, and indecipherable. We would recommend that the limitation in the bill that refers to encryption be broader so that we're looking at what the test is. And really this creates market-based incentives that supplement the regulatory authority that's given. It's that combination that will ensure that more holders of data ensure that even if there is a breach, that the party that has carried out the breach or the unlawful entity can't do anything with that data. And that's an important safeguard. Fourth, we believe that your bill takes an appropriate risk-based approach to securing data, and we support the grant of authority and would recommend that it be limited to the FTC and state attorneys general rather than extending a private right of action. A couple of comments about H.R. 1319. We welcome this effort by Ms. Bono Mack and other members of the subcommittee to address this issue. Consumer privacy can be and is being compromised because of certain peer-to-peer file sharing applications. We also appreciate this subcommittee's willingness, the committee's willingness to look at the current breadth of this bill to identify where it could be appropriately limited. We do believe that there are two goals in this. One is to protect consumer security and promote trust, and the second is to ensure that technological innovation continues to proceed. It is this balance that must be struck, and it must be struck carefully. We are all concerned that the bill, if it is in its current form, could pull in some of the very legitimate applications and uses of peer-to-peer technology that are important for every consumer, important for legitimate companies. As it seeks to look at some of the bad actors or some of the peer-to-peer software that we widely know as an anti-piracy organization that have led to the widespread theft of software, music, movies, and other content, we also know that the bill in its current form could sweep in any Internet-aware features of software, such as automatic updates for antivirus software, such as the crash analysis feature of operating systems or the web browsers on our computers. We know that that is not the intent of this bill, but as written, it could reach that breadth. And so we would urge the committee to recognize that while some effort should be made, it is important to enhance security. We also want to ensure that the technological progress and growth proceeds, and that will benefit all users of legitimate software. So on behalf of the BSA, thank you for this opportunity and look forward to your questions.
The gentleman, Mr. Lafferty, for 5 minutes.
Chairman Rush, Ranking Member Radonovich, Subcommittee members, thank you for holding this important hearing. I'm Marty Lafferty, CEO of the Distributed Computing Industry Association. Both of the bills under consideration have far-reaching consequences. Our expertise relates primarily to H.R. 1319. DCIA is a trade group focused on P2P and related technologies. Our mission is to foster commercial development of these technologies so that their benefits can be realized by all participants in the distribution chain, including content rights holders and Internet service providers. We currently have 125 member companies, including P2P, cloud computing, file sharing, and social networking software distributors, broadband operators, content providers, and service and support companies. P2P has evolved greatly in the 8 years since Napster first brought the term P2P file sharing to prominence. Fully licensed ad-supported P2P, subscription P2P, paid download P2P, commercial enterprise P2P, P2P TV, hybrid P2P, and live P2P streaming now deserve to be separated from the narrower subset of functionality associated with file sharing. DCIA member companies increasingly use P2P for the delivery of authorized entertainment and corporate communications content where rights holders, rather than end users, introduce files or live streams for online delivery. We strongly urge the committee to apply the term file sharing without the P2P prefix as a more accurate descriptor for the focus of H.R. 1319. The Committee on Oversight and Government Reform held a hearing on this topic in July 2007 at which one of our member companies testified. Within weeks of that hearing, the DCIA established the Inadvertent Sharing Protection Working Group. Over several months, we recruited participants among leading P2P and other tech sector companies and engaged with FTC staff to address issues associated with unintended publishing of confidential data by file sharers. This effort began by providing demonstrations for FTC staff of how current file share programs work in terms of users uploading material for distribution. It continued through an iterative process involving private sector and regulatory participants to develop a program of voluntary best practices for file sharing software developers to protect users against inadvertently sharing personal or sensitive data. This program was announced in July 2008. Its summary, included in our written testimony, begins by defining terms relevant to 1319, such as recursive sharing, sensitive file types, and user-originated files. It then outlines 7 steps that are required to be in compliance: default settings, file sharing controls, shared folder configurations, user error protections, sensitive file type restrictions, file sharing status communications, and developer principles. The principles address feature disablement, uninstallation, new version upgrades, and file sharing settings. In August 2008, the DCIA announced that compliance monitoring would begin in December to allow developers time to integrate required elements of the ISPG program into their planned upgrades and new releases. Compliance monitoring resulted in reports from top brands that use P2P for downloading, live streaming, open environment sharing, and corporate intranet deployments, and for both user-generated and professionally produced content. Specifically, 7 leading P2P representative program distributors submitted detailed reports to FTC staff in February 2009. In March, the DCIA prepared and submitted a summary. We also noted that software implementations of the popular BitTorrent protocol typically require users to conduct a deliberate conversion process from whatever native file format their content is in to a torrent file before it can be published, thus minimizing this risk of user error. The entire report, plus data tables of individual company submissions, are in our written testimony, but here are highlights. All respondents now have clearly disclosed install default settings that only permit sharing files downloaded from the network. they do not share user-generated files by default. 100% also provide complete uninstallation of their file-sharing software that's simple to do and explained in plain language, for example, by using the standard add remove program in Windows. And 6 out of 7, which is all where this is applicable, now offer a simple way to stop sharing any folder, subfolder, or file by using easily accessed controls. In April 2009, subcommittee staff invited the DCIA to participate in redrafting H.R. 1319. We formed a DCIA member subgroup to conduct this work. The process is underway, and we'll be glad to coordinate that work with staff. Among our greatest concerns is that the bill, as drafted, would have unintended consequences. The present draft goes way beyond the specific concerns discussed here and would apply to additional functionality and technologies that have nothing to do with recursive sharing of sensitive file types. Applying these requirements to numerous products, services, and companies would be burdensome and counterproductive. To the extent that legitimate consumer concerns persist in the area that the bill intends to address, we strongly believe they can best be handled by ongoing self-regulation under the oversight of the appropriate federal authority as we initiated with the ISPG. The bill as constructed would unnecessarily burden U.S.-based technology firms with innovation freezing constraints while being unenforceable against overseas competitors' software is available to U.S. consumers. The great concern also is how it might stifle yet undeveloped new and potentially very useful and valuable software applications. On the other hand, the DCIA has committed to self-regulation through the ISPG to address the subject matter of this bill and is making substantial progress. So rather than a problematic new legal measure, we believe that formalized requirements for compliance with that process will be more effective in achieving the purpose of the bill. We look forward to working with the subcommittee on these issues in a productive manner that will benefit all your constituents. Thank you for your continued interest in our industry.
The chair thanks the gentleman. The chair now recognizes Mr. Pratt for 5 minutes for the purpose of an opening statement.
Chairman Rush, Ranking Member Radonovich, and members of the subcommittee, thank you for this opportunity to appear before you today. My name is Stuart Pratt, President and CEO of the Consumer Data Industry Association. Our 250-member companies provide our nation's businesses with data tools necessary to manage risk and a wide range of consumer transactions. And these products include credit and mortgage reports, identity verification tools, law enforcement investigative products, fraud check transaction identification systems, decision sciences technologies, location services, and collections. My comments today will focus exclusively on H.R. 2221. We applaud its introduction. CDIA's members agree that sensitive personal information should be protected. We also agree that consumers should receive breach notices when there is a significant risk of them becoming victims of identity theft. Our members agree with the Federal Trade Commission recommendations, which embrace these two concepts. I would only add that if a federal law is to be enacted, it should be a true national standard. We believe that data security and breach notification provisions in H.R. 2221 would be most effective if they were better aligned with requirements found in other current laws. Alignment is key to ensuring that all who are affected by the Act are successful in complying with new duties under data and also with their current duties found under other laws such as the Fair Credit Reporting Act and the Graham-Leach-Bliley Act. Let me discuss some of the ways that 2221 interplays with existing duties found in current laws. Section 5.6 defines the term information broker. Absent aligning this definition with other current laws, our members' products will be affected. This bill would require information brokers to have reasonable procedures to verify the accuracy of personal information, provide consumers with access to these data, and ensure a system by which consumers can dispute information. All of our members operate consumer reporting agencies, as this term is defined in the Fair Credit Reporting Act. They produce data products defined as consumer reports. Consumer reports are used to make determinations of a consumer's eligibility for a service or product, and the FCRA establishes duties for accuracy, access, and correction as it relates to these products. Our members agree that where data is used to make a decision regarding consumers' eligibility for a product or service, consumers should have these rights. Since there are similar duties under the FCRA and data, we propose the definition of information broker should be amended to exclude the term consumer reporting agency. And while we appreciate the inclusion of Section C3C, which attempts to address our concern, we believe that since the FCRA's duties are well understood and the FTC has direct enforcement powers, that we should have a complete exemption. Regarding disclosure, Section C3 allows an information broker under certain circumstances to not disclose personal information to a consumer. The section does not exempt an information broker's fraud prevention tool from the duty to verify accuracy, however. Fraud prevention tools are designed to identify the possibility of fraud, and to apply an accuracy standard to fraud prevention tools is unworkable, since these tools are designed to warn a lender or a utility or other business about the possibility of fraud. Fraud prevention tools consider how data is been used in previous identified cases of fraud and employ many other relational strategies. We would urge the expansion of C3B3 to include fraud prevention tools so that they're completely exempted from the accuracy standard requirement, not because the tools are designed poorly, but because these tools cannot line up with an accuracy standard in the first place. Your bill also, as indicated, establishes both a requirement for data security and a requirement for security breach, and we have absolutely no qualms about either of those requirements. Our members, in fact, comply with those types of requirements today, and our only request is that where our member companies are already operating as a consumer reporting agency under the Fair Credit Reporting Act, or where they're operating as a financial institution under the Gramm-Leach-Bliley Act, that they would be exempted from these data security and these security breach notification duties because they already have those duties under the Fair Credit Reporting Act and also under the Gramm-Leach-Bliley Act, and in particular the safeguards rules, which include breach notification. So this process of alignment will make this bill more effective. If we can make this truly a national standard, you certainly will have filled some gaps along the way. I think that Mr. Sohn said it very well. In the meantime, we live with a range of state laws. We have worked constructively with many, many states in establishing those statutes and in establishing definitions of the crime of identity theft. And we will continue to do that, and we look forward concurrently to working with you in the committee. Thank you.
Thanks to the gentleman. And now the chair recognizes Mr. Rotenberg for 5 minutes.
Mr. Chairman, Mr. Radonovich, members of the committee, thank you very much for the opportunity to be here today. EPIC is a nonprofit research organization here in Washington. We have a particular interest in this issue of security breach notification. EPIC was the organization that had urged the Federal Trade Commission to investigate the data practices of a company called ChoicePoint, because we believe that that company was making the personal information of American consumers vulnerable to misuse. The FTC did not heed our warning, and instead we all read in the newspapers when an investigation broke in Los Angeles that revealed that the records of 145,000 American consumers had been sold to a criminal ring engaged in the act of identity theft. I promise you, after that news story appeared, the FTC and many state attorney generals became very interested in this problem. Now, we learned of the problem with ChoicePoint in part because of a good law that had been passed in the state of California, which required companies that suffered from a security breach to notify people who were impacted. And as a result of the ChoicePoint notification, many other states began to understand the need for security breach notification. Now, this has been an evolving process. I think there are now 44 states in the U.S. that have security breach notification. And while we certainly support an effort to establish a high standard across the country, I do want to warn you that one of the consequences of this bill would be to effectively tie the hands of the states from further updating their laws or enforcing stronger laws. And I think this would be a mistake. I read recently, for example, that the California State Senate has just approved new changes to its notification law that would provide individuals with better information about the type of personal information that was improperly disclosed and how it might be misused. This need to be able to continue to update security breach notification, I think, should be a consideration as the committee looks at legislation to establish a national standard. One of the other points I'd like to make about the legislation concerns the relationship in the realm of notification between the individuals who are impacted and the role of the Federal Trade Commission, which is also notified under the bill. There is understandable concern that if individuals receive too many breach notices, they will serve no purpose. And so there's a need to set a standard so that people are not receiving lots and lots of these notices which they'll come to ignore. But with respect to the role of the Federal Trade Commission, I think the bill could be strengthened by requiring companies in all circumstances to notify the Commission where substantive breaches have occurred, and moreover, to put on the Commission an obligation to be more transparent about the information that it receives regarding the problems of breach notification in the United States. There is also a risk with the legislation as it's currently drafted that the FTC will obtain information about security breaches, may choose not to act on the information it receives, and that information will effectively remain secret both to the public and to this committee, and the problem will continue to grow. So I hope that is an area that can be considered as well. We talk also about the safe harbor provisions, essentially companies that have certain security practices, such as encryption, should be encouraged to put in place and maintain those practices. But again, we think that notification can be made to the Federal Trade Commission in those instances where security breaches occur, even if it may not be necessary to notify the target population. Finally, I'd like to point out that since when the bill was originally introduced, there have been significant changes, both in the Internet and also in communications technology. Facebook, for example, now has 200 million users. 4 years ago, when this bill was first considered, there were many, many fewer people using these social network services. This has two implications. First of all, there is a new way to notify people online. It's no longer necessary to talk just about a website, but also a social network presence. It also means that there's a new risk in data collection that needs to consider the growing significance of social network services. And finally, I might mention that text messaging has become a very effective way to notify people about things that might concern them regarding security. We propose in our testimony that where possible, text messaging be used as a supplement to the other notification procedures, including mail and email. So thank you again for the chance to testify, and I'd be pleased to answer your questions.
The chair now recognizes Mr. Moback for 5 minutes.
Chairman Rush, Ranking Member Radonovich, and distinguished members of the committee, I thank you for giving us the opportunity to testify here today. As many of you discussed in your opening statements, the security risks associated with peer-to-peer, our company, Tyversa, of which I'm the CEO of, has a unique insight on this, in that Tyversa has the unique technology that allows us to span out globally to see all information that's occurring on all the peer-to-peer clients. So it's not just a LimeWire or a Kazaa or a BearShare, it's everyone, all-encompassing, and we see it in real time. So therefore, this provides us a great insight to provide information to the committee here today. This information that we're finding is very sensitive. There are security measures, so I commend the Honorable Ms. Bono-Mack for bringing this here today. The reason why is that many security professionals around the world in high-ranking positions in corporations in the United States and abroad aren't even aware of this. So again, for her insight to bring this to the committee and bring 1319 forward, it's very important because again, the awareness is still not where it needs to be. For instance, in the last 60 days, despite the measures that have been taken by the peer-to-peer clients, despite which I also admit are improving. LimeWire is improving its protocols to decrease the amount of breaches that have happened. But in the last 60 days, Tyversa has downloaded breaches in the amount of 3,908,000 breaches, individual breaches, in the last 60 days. I find it very important that 2221 and 1319 are actually discussed on the same day. The reason why is this is where breaches are happening. As Mr. Gringy of Georgia called out, obviously we all saw the Wall Street Journal article April 21st about the Joint Strike Fighter. It wasn't reported in the Wall Street Journal. This was peer-to-peer. The information, unfortunately, is still on the peer-to-peer. This was discovered in January 2005. We discovered it. We reported it to the DoD. It's still here. It's still out there. It's never been remediated. Awareness is not where it needs to be. Oversight is not where it needs to be in order to address these problems. That's the type of national security ends. Now, there are also the consumer ends. From Tyversa, we process 1.6 billion searches per day. Every day, Google is about 170 million per day. So we were about 9 times what Google is processing on a daily basis. In those searches, we're able to see what the users are looking for around the world. And in those searches, we see people searching for your financial records. They are not looking to apply for a credit card. They are not looking for health insurance. They're looking for your health insurance because they want to quickly go online and buy online pharmaceuticals using your medical insurance card as medical identity theft. No credit monitoring will stop that. They want to get your Social Security number filed with your tax return. We did a study with a live show with the Today Show showing that in that instant, 275,000 tax returns were found in one search on the peer-to-peer. So a minimum of 275,000 Social Security numbers on one time. Now, we've done other searches where it's been over 500,000 on one time. And yet, I would also say, strongly urge the FTC that on the website where it would identify to users that this information is coming from the peer-to-peer, there's not one mention of peer-to-peer on where are they getting your information. 9 million victims every year of identity theft, and the number one mention on the FTC's website is dumpster diving. It doesn't add up. The numbers don't add up to dumpster diving. Consumers are not aware of this problem, not from a national security standpoint. Executives don't know it. Security executives do not know this problem. Consumers aren't aware of this problem. They need to know that their information is out there and it's being sought after on an enormous scale, such that even in our research in the last few months, we've had a 60% increase in searches for information that will lead to identity theft and fraud. This is a serious growing problem that consumers, again, are not aware of. So we applaud 2221 for a national breach. I will tell you that as we find these breaches, these 3,900,000 breaches, as evident as we can, we return the information and alert the companies to the breach. Again, we do it out of our duty of care policy. There is no strings attached to that. I will tell you that there are thousands of cases that our individuals, our employees, have provided to users, to companies nationwide, that they completely disregard the breach. Many of those are actually cited in my written testimony. So you would think that you're safe if you do not use peer-to-peer. Well, I will show you in the written testimony there are users out there that all they did was go to the hospital and they provided their information there. And now that's one of the things. So individuals need to have an identity theft protection service as well as a national breach notification such as 2221. And I thank you for the opportunity and welcome questions.
Thank you very much. Now the chairman recognizes Mr. Sittner. Mr. Sittner, you're recognized for 5 minutes for opening statements.
Thank you, Chairman Rush, Ranking Member Radonovich, and members of the subcommittee. My name is Tom Sidnor, and I'm a senior fellow at the Progress and Freedom Foundation. I'm here speaking today on my own behalf, and I'm also the author of 2 studies on the causes of inadvertent file sharing programs and technological features to induce users to share, published by the United States Patent and Trademark Office, and Inadvertent File Sharing Revisited, published with the Progress and Freedom Foundation. And I'm here today to testify in support of H.R. 1319, the Informed Peer-to-Peer Users Act.
Mr. Sidnor, would you please excuse me just for a moment? I wanted to alert the members. It's a little over 5 minutes for this is a 3-series vote. There are 3 votes in this series, and that would be the last votes of the day. So if members want to leave to go and vote, after this witness completes his opening statement, then the chair will recess the committee and reconvene at the conclusion of this series of votes. So we ask that the members please return promptly so that we can complete our questioning of these witnesses and complete this hearing. Mr. Sidner, would you please continue?
Thank you, Mr. Chairman. And I'm testifying today in support of the bill because my written statement and my past published work on inadvertent sharing, I think, shows that in the past we have tried to rely on voluntary self-regulation, and it has failed. Voluntary self-regulation should be an incredibly important part of our technology policy, and for that reason it must be taken seriously. Unfortunately, in the context of distributors of file sharing programs used mostly for unlawful purposes, it has been tried, voluntary self-regulation. It has failed miserably in the past, and I can report that it is failing again right now. I want to consider, for just as an example, the file sharing program LimeWire 5. The DCIA has hailed LimeWire 5 as the gold standard for the implementation of its new voluntary best practices. And LimeWire itself has, as a result of this hearing, generated great publicity for itself by telling Congress that at long last, LimeWire 5 put the final nail in the coffin of inadvertent sharing of sensitive files. And the problem is that last statement is not even arguably correct. And to show why, I want to consider a hypothetical based upon the recent reports from Today Investigates, showing that in New York State alone, researchers could find over 150,000 inadvertently shared tax returns. The report also showed the real-world consequences of inadvertent sharing by profiling the Bucci family, who had their tax returns stolen by an identity thief because they had inadvertently shared their tax returns because their preteen daughters were using a file sharing program reported to be LimeWire. But the real problem in such a case is that a tax return is really only the tip of the iceberg. Such episodes usually mean that a family is sharing all of its personal data files stored on the family computer. All of the parents' work and personal documents, scans of legal, medical, and financial records, scanned documents providing identifying information about the family's children, all of the family's digital photos, all of its home videos, entire music collection, probably thousands of files. Consider two families that have been affected by this type of catastrophic inadvertent file sharing, and just assume it was caused by an earlier version of LimeWire. Consider what happens if they upgrade to LimeWire 5. One family doesn't know they have a problem. They are unaware that a problem exists, but they hear reports that LimeWire 5 has ensured the complete lockdown of the safety and security of LimeWire users, and so they upgrade to LimeWire 5. Will that correct their inadvertent sharing of sensitive documents problem? It will not. By default, simply by being installed, the family will continue to share documents that are, by any definition, reasonable definition of the word, sensitive. They will continue to share the family photo collection. They will continue to share scanned legal, medical, financial records, perhaps even tax returns. They'll continue to share data about their children. They will continue to share all their family, their home videos. They will continue to share their entire music collection. And so they will continue to be exposed to the full range of risks: identity theft, data on their children getting into the hands of the pedophiles that use these networks, and risk of a lawsuit. Now, the other family does know their problem. They detect it, and they resolve it by uninstalling LimeWire, remove it from their computer. So this family actually has put the final nail in the coffin of their inadvertent file sharing problem. But they hear about LimeWire 5. Their kids reinstall it because now it's completely secure. What will happen? By default, simply by being installed, that program will revive, will call back from the dead, the family's inadvertent file sharing problem. It will automatically begin resharing all the data files that were shared before, except for some types, simply by being installed. That is not acceptable behavior. It is not acceptable practice, and I think it indicates why we need to, why the committee should be commended for its work on H.R. 1319. Thank you.
The chair thanks this witness and all the witnesses. Now the chair will ask that this committee stands in recess until such time as we return from a series of 3 votes. I would ask the witnesses if you please would wait so that the members can come back and ask questions. Thank you so much. The committee is in recess.